Attorney Garza, you may call your first witness.
I call petitioner Renee Velasquez.
Okay.
Mr. Velasquez, can you please state your full name for the court, please?
My name is Renee Antonio Velasquez Orellana.
Mr. Velasquez, how many children do you have with respondent Marlene Ramirez?
2.
And what are their names and ages, please?
Diego Velasquez, 6 years old. Isabel Velasquez, 5 years old.
Thank you. Your Honor, at this time, I ask the court to take judicial notice of the order that is on record with this court, the order for in suit affecting parent-child relationship that was entered by this court December 26th of 2023. That's the order that we are enforcing today.
Okay, the court takes judicial notice of the order as well as all contents of the court's file.
Thank you. In your order in suit affecting parent-child relationship entered by this court on December 26th of 2023, Mr. Velasquez, what kind of conservatorship were you awarded as to your children, Diego and Isabel?
I have joint conservatorship.
Okay. Who was given the right to designate the children's residence?
This enforcement hearing opens with a familiar but high-stakes question in family court. When a court order is clear, what happens when one parent claims it's repeatedly ignored? The petitioner, Renee Velasquez, takes the stand seeking enforcement of a 26 December 2023 SAC order. 2 young children are involved, Diego, 6, and Isabel, 5, making every alleged violation more serious in the eyes of the court. The judge is not here to relitigate custody, but to determine whether the order was followed as written. Text messages, possession schedules, and technical compliance will matter. This case is about proof, not emotion, and enforcement hearings live or die on documentation.
Mrs. Marlene Ramirez.
Okay. Were you awarded a possession schedule to see the children?
Yes.
Can you briefly tell the court what your possession schedule was in terms of the Thursdays?
On Thursdays, I have every Thursday of every week from 5 in the afternoon until 7 in the afternoon.
Okay. And is that only during the school year?
Yes.
And in order to exercise your Thursday time, are you ordered to also contact Ms. Ramirez by text that Monday of that week by 5:30?
That's correct.
That's deleting.
Early testimony carefully establishes the foundation required for enforcement. The court takes judicial notice of 26 December 2023 order confirming joint conservatorship and the mother's exclusive right to designate the children's residence. Importantly, Mr. Velasquez confirms he was awarded a specific Thursday possession schedule during the school year. This matters because enforcement cases hinge on precision, days, times, notice requirements. The order requires Mr. Velasquez to text the mother by Monday at 5:30 p.m. to exercise Thursday visitation. This testimony is not dramatic, but it is critical. Without proving the existence and clarity of the order, no enforcement action can legally proceed.
In the order, Are you ordered to contact me? Overrule, I'll allow it.
Okay. From the time that this order in suit affecting parent-child relationship was entered in December 26 of 2023 until shortly before the time you filed this lawsuit to enforce your possession time and other conservatorship rights, were you seeing both children according to the possession schedule that you were awarded?
Yes.
Okay. Before you filed this enforcement lawsuit, was there a time that you experienced that either of your children were resistant to returning to their mother, Marlene Ramirez?
I'm going to object as to leading and to relevance.
Your Honor, the whole point of the enforcement is that the children were not, my client was not given access to the children, and this.
When questioning turns toward whether the children resisted returning to their mother, the courtroom dynamic shifts. Objections fly, and the judge steps in to narrow the scope. Enforcement hearings are not the place for speculative explanations or emotional narratives unless they directly relate to compliance. The judge sustains objections on relevance, signaling that motive does not excuse violations. This moment underscores the court's priority. Was the order followed, yes or no? The judge's insistence on relevance keeps the hearing disciplined and focused. It's a reminder that enforcement is not about parenting styles, it's about whether a court order was obeyed exactly as written.
What I'm asking my client about goes directly to that. That's what started this whole thing.
Before you filed this enforcement lawsuit, was there a time that you experienced either of your children were resistant to returning to their mother? Sustain as to relevance.
Mr. Velasquez, please briefly respond to that question.
No,
Yes.
You should
Yes.
stay as to relevance.
Oh, I'm sorry. Okay. Let's go to, let's please look at Exhibit B. I'm going to share that on the screen. Your Honor, may I do that?
Yes.
Okay. Oh. Let me pull this up.
Exhibit.
I don't have the evidence on the screen, so
Oh, okay. Did you text Ms. Ramirez to tell her you?
The presentation of exhibits marks a turning point. Screenshots of text messages become the backbone of the petitioner's case. Mr. Velasquez testifies that on 8 September 2024, he properly notified Ms. Ramirez at 5:32 p.m., complying with the Monday notice requirement. On Thursday, 12th September, he arrived and texted at 4:57 p.m. requesting both children. Only one child was released. This testimony directly supports an alleged violation of the court's order. The court is now moving from theory to proof. Timestamps, locations, and exact compliance are placed squarely before the judge.
Were there to pick up the kids.
yes, every time that I go pick up the children, I will send Miss Marlene a text message letting her know that I'm outside.
Okay. When you're alleging that she failed to release your son, did you go up to the door? Of the residence of Miss Ramirez?
I went up to a gate where I can access her property.
And did you call her?
I sent her a message.
Okay. Did you make a police report?
On what date specifically?
The testimony continues with 2 more Thursdays, 19th September and 3rd October 2024. Each time, Mr. Velasquez claims he followed the same procedure: timely notice, arrival at the residence, and text confirmation. Each time, he asserts that only one child was released. The repetition matters. Enforcement courts often look for patterns, not isolated incidents. These alleged denials form the basis for violations 2, 3, and 5 in the motion. However, the court also begins pressing for clarity, forcing counsel to match testimony precisely with violation numbers. Organization and accuracy become just as important as credibility.
In violation number 2, you allege this occurred on Thursday, September 12th.
No.
Let's move to alleged violation number 3, which violation number 3 on the motion for enforcement, but it's your second violation alleged today on Thursday, September the 19th. You sent a text message to Ms. Ramirez telling her you were there to get the kids, right?
Correct.
Okay. And you're alleging that she did not release the child, Diego Velasquez, to you. Is that correct?
That's correct. She only gave me my daughter, Isabel Velasquez.
I'm going to object as to non-responsive after yes.
Sustain.
Beyond possession, the case expands into conservatorship rights. Exhibit C introduces a different issue: access to school information. Mr. Velasquez testifies that he repeatedly requested the children's school identity beginning 30th July 2024 and never received it. This is significant because joint conservatorship includes the right to participate in educational decisions. Without knowing where the children attend school, those rights are effectively blocked. This allegation supports violation number 20. The court now must consider whether the respondent's actions interfered not just with possession, but with core parental decision-making authority granted by the order.